A big part of people's life is on social media, especially today, and especially with the younger generation. And when you come into my office as a potential client, we're going to go through that. And I'm going to need to know all of the social media that you participate in. And we're going to look at your pages on Facebook, Twitter, MySpace, Instagram, or whatever social media you subscribe to, and we're going to look at your life, because you have a life before you came to my office. And that might potentially be evidence in the case. And if we anticipate together that we might have to file a lawsuit in your case, then we have an obligation to preserve that evidence. Because down the line, the defense attorney will undoubtedly want to see it. They want to know about your life before this tragedy happened to you. And a judge very well may agree with them that that's relevant. And we may have to disclose that life of yours on the web. And so it's important for the client to tell me about it, me to review it, and us to preserve it together. So that if down the line a judge orders that the defense gets to see it, it's still preserved. So for the older folks like myself, we had diaries growing up, or journals, and we would write all of our thoughts, our private thoughts for the most part, in our diary, usually with a lock and key, and we put it up on the shelf. And that's private. We wouldn't think that anyone would have the right to get that. But today, people have a video diary or a video journal, because everything they post on social media really is that diary that we had long ago on top of the shelf. And a defense attorney may very well request the diary on the top of the shelf, or the video diary on social media. And it's really the same thing, just in a different format. And it's hard, especially for the younger generation, to understand, because they live their life on Facebook. It's hard for them to understand and grasp why it is that anyone could see that, especially if they have their privacy settings enacted, which are very important to have enacted. Otherwise, the defense attorneys are immediately going to go onto social media the second they get notice of your claim and look you up. And if you don't have your privacy settings enacted, you need to do it right away, because you don't want the wrong eyes looking at your diary. Now, putting your social media settings on privacy does not mean that you're destroying evidence or removing content from your websites. It just means that only the folks that you want to see what you're posting on the web will see what you're posting on the web, as opposed to someone peeking in that you don't want to see it. Conversely, another reason why it's important to keep everything on your social media websites, you enact your privacy settings, but you don't destroy anything. You keep everything that's there. It's because very well that evidence may help you in your case. For instance, if you are catastrophically injured due to some sort of accident or incident, and before the injury you were very active, you were a snow skier and you climbed mountains and you sled and you do all sorts of fun things, you run and you're active, those photographs and video are going to be very helpful to you in proving your case and in showing a judge or a jury what your life was like before and what your life is like now, and contrasting the two. So the evidence on your social media sites can actually help you as well. So it's not automatic. What typically happens is the defense sends a discovery question, a request to produce, or an interrogatory asking for your client's information, all of the social media websites that your client is on, and their usernames and passwords. It's our job, representing those clients, to be the gatekeeper of that information. I do not, for instance, give out usernames and passwords of my clients' social media sites. mostly because they don't want me to. They find it an invasion of privacy. And until I have the chance to go through everything and determine what's relevant and what's not relevant, we will object to that information. And then the judge ultimately will decide whether or not we have to give up the usernames and the passwords to those social media sites. And we try to work with opposing counsel and give them the information that we think would obviously be helpful to our case, and not voluntarily give them information that would be hurtful to the case. But it gets to a point where it's beyond our control, and a judge may deem it relevant and may order us to give the username and passwords of our clients' social media information to the defense.